Welcome everybody. Thank you for coming to this Your Questions Answered session on the UK's new immigration system. I'm Sarah Springford and I'm the CEO at Brighton Chamber, and I'm going to be your host today. So today's event is part of the From Brighton with Love series. From Brighton with Love includes a series of expert panel events, Your Questions Answered sessions, and Export Leaders Peer Network sessions. All the sessions are held virtually, open to all and free to attend. This new initiative is led by Brighton Chamber and supported by Brighton and Hove City Council with our event partner, Brighton and Hove Economic Partnership. And its aim is to provide Brighton area businesses with expertise that will see them through the EU transition and beyond. I'm delighted to be joined today by a team from Fragomen, worldwide immigration attorneys, solicitors and consultants. So I'm going to just tell you a little bit about our four experts. So Kasia Pinska is director and Andrew Barnett is a senior manager at Fragomen, and both are experts on immigration into Europe. They are the people to speak to if you have employees moving to Europe or even just visiting for short periods to do more than just hold meetings. Their team of 30 legal experts can help you navigate the rules in specific destination countries. Katie Good is an expert in UK immigration on all things other than asylum policy. Katie can help you with your own immigration status or get your business to a position where you can sponsor and employ skilled workers from overseas. And Ian Robinson is a partner and works with Katie on UK immigration. He also manages client accounts that operate almost everywhere else in the world, and he and his team could help wherever you need to employ people. So the UK's new immigration system is now in place, and it's becoming increasingly important for employers to get to grips with what it means for existing employees and job applicants. Europeans who were in the UK before 2021 must make an application under the EU settlement scheme, and new hires will normally need to be sponsored, a technical process that needs to be done properly. On the flip side, UK nationals have lost their right of free movement in Europe, creating a host of practical challenges for work and business. The aim of this session is to help you understand what is needed for both groups and how you can get on the front foot. There will also be a chance to ask, obviously, additional questions. If there are questions that are quite specific to your business, we may suggest that you follow up with Ian and the team afterwards, and we'll be sharing contact details with you. If it's one or two quick questions and you mention Brighton Chamber, they're very happy to answer these for you. If it's more complex, they may advise you that there may be a cost to investigate further. So we're going to start with a 15-20 minute whiz through some of the essentials and a bit more. So first of all, it's Katie. Over to you, Katie.
Thank you very much, Sarah. I'll just wait for the slides. Perfect. If we could just go to the next slide and I'll just go through the agenda. So I'm going to begin this brief presentation with talking about the EU settlement scheme. So the applications that EU nationals who are living in the UK before the 31st of December 2020 need to make. And then I'll pass on to Ian, who will talk about the new immigration system in the UK. And finally, I'll pass on to Andrew, who will discuss immigration in Europe. So if I just go to the next slide. So in very brief terms, I just want to explain a little bit about what the EU settlement scheme is. So all Europeans who are residing in the UK on or before the 31st of December 2020 have to make an application under the EU settlement scheme by the 30th of June of this year, so in about 6 weeks' time. It's really important that they make this application in order to guarantee their status in the UK after the 1st of July 2021. It's been open for the past few years and it's very easy to apply, and I'll go through an overview of how you make that application. But if an individual doesn't make this application from the 1st of July 2021, there will be a substantial personal risk because they will be considered non-compliant with the immigration rules, and they may lose their right to work, reside or study in the UK. So if we just go to the next slide, and I'll just run through how the process works. So as I said before, it's very easy to apply. It's free of charge, and EU nationals will just need to download an app called the EU Exit ID app on any iPhone or Android device in order to complete an identity check, which essentially means they have to scan their passport using the app. They have to take a selfie, they have to scan their face, and then after they've completed the identity check, then they'll need to complete a very brief online application form, which will ask some basic questions like their national insurance number, their current residential address, and if they've had any previous criminal or civil convictions. And once they submit the application, the Home Office will firstly, they'll do an initial check with the HMRC against the national insurance number in order to determine how long the individual has been in the UK for. So if their national insurance records determine that they've been in the UK, they've been paying tax for a continuous period of 5 years, the Home Office will make an initial assessment and they can be granted something called settled status or permanent residency. Now, if an individual has been in the UK for a continuous period of 5 years, but hasn't been paying tax for that period of time, that's absolutely fine. They'll just need to upload additional evidence of residence, and I'll go through that in the next slide. If an individual has been in the UK for less than 5 years, then they'll be granted something called pre-settled status, with then the opportunity to upgrade their status to settled status or permanent residency once they've completed 5 years in the UK. So I'll just go on to the next slide. So really importantly, it is also possible for non-EU national family members of EU nationals to make an application. For example, a French national who has an American partner. In order to qualify, they have to prove that their relationship started, i.e., for example, they have to be married or in a civil partnership by the end of the transition period, which is the 31st of December 2020. They have to meet the criminality threshold, and importantly, they can apply at any time. So as long as their EEA sponsor, then their wife or civil partner or mother, for example, as long as they've applied, the sponsor has applied before the end of the transition period, so by the 31st of December, the family member, the joining family member, can apply at any time. So they're not subject to the same deadline of the 30th of June 2021. And this is also the case if they have any children that were born after the end of the transition period as well. So just moving on to the next slide. So as I said before, you have to prove that you're a resident in the UK. And the easiest way of doing that, if you have been paying tax for a continuous period of 5 years, is to provide your national insurance number, but that's not often the case. So the Home Office also accept multiple different types of evidence of UK residence, and I've provided a few examples there. The Home Office have advised individuals to provide evidence that covers a longer period of time, because then you have to provide less documents. So say, for example, you were a student at a university in the UK, you could simply provide either your degree certificate or transcripts, and that would cover you for that full 3-year period or however long your studies are. So you don't need to provide any further evidence. Now, if you're applying for pre-settled status, i.e. you've been in the UK for less than 5 years, you'll just need to provide a document dated in the last 6 months, which shows that you were resident in the UK before the 31st of December. Now, if you entered for one day, say in November, and you had your flight ticket and you bought a coffee from Starbucks as an example, that would suffice. That person can then apply for pre-settled status. They would have that permission for 5 years. And if they meet the requirements in order to apply for settled status, which I'll go through at the end, then they would be eligible to apply under the scheme. Then just moving on to the next slide. So then if an individual is a non-EA national and they're applying on the basis of their relationship with an EA national, they'll also need to provide evidence of that relationship. So for example, if they're married, a marriage or civil partnership certificate. And if an individual has been living with the EA national for a period of 2 years, they will also qualify, but they'll have to provide evidence of cohabitation for that full 2-year period. So then just moving on to the next slide. So once the application is approved, the individual will be granted a digital status. They won't receive any visa if they're an EEA national. It will all be linked to their passport, and they'll be able to show their online status and share it with an employer or a landlord as evidence of their right to work and rent. And just finally, so if an individual has been granted pre-settled status, they will be eligible to apply for settled status once they've completed 5 continuous years in the UK. And that means they can't spend more than 6 months in any 12-month period outside of the UK. Apart from, they can have one period of up to 12 months outside of the UK if they have a valid reason, which is, for example, maternity leave, sick leave, or due to the travel restrictions caused by the pandemic. But importantly, it's just one period of 12 months. They would then make the application again and they could apply for settled status. So that was a whistle-stop tour of the EU settlement scheme. I'm now going to pass over to Ian, who's going to talk about the new immigration system that's come into effect this year in the UK.
Yeah, thank you, Katie. So before we go on to the next slide, I just to underline, we thought it was really important to talk about the EUSS scheme, because where you personally or you have employees who are European and were in the UK before the end of last year, it's so important that they make an application under this scheme. If they don't, they will face the same hostile environment that ruined the lives of members of the Windrush generation. So it's so important that they apply, but it doesn't need to be a difficult application. One of the resources we will send over to Sarah and the Chamber afterwards for them to circulate to you all is an employer toolkit on the EUSS, and in there you'll have an email or letter template that you can send to your employees explaining what they do and why it matters. You'll have a guide, online guide that you can give to them so that they know how to make an application, a video, an FAQ, and certain other resources. We just want to make it as easy as possible for you to advise them, really, because it's so important to people that they make an application and don't find that their life is turned upside down afterwards. If we move on to the 2 slides, please, Laura. So I'll just talk about the new UK immigration system. I know we've had a few questions coming in already, and there may be more, so please ask them. But the main points here are the UK's involvement in free movement of European nationals ended at 11 o'clock on New Year's Eve, just gone, New Year's Eve 2020. What this means is that we've got a new immigration system for everybody in the world other than Irish nationals, and Irish nationals can continue to come and go as they wish. If you're used to recruiting European workers, what you're going to find is that it's going to take longer, it's going to be more complicated and more expensive. Government fees, which I'll come to, are really high for UK immigration. It will be much harder, sometimes impossible, to employ low-skilled European nationals other than where they're self-sponsored. But you may be able to work with the system. If you're used to recruiting non-European people, actually, the system will be no cheaper. It will still be really expensive, but you're going to find a simpler system. Before you can do anything, though, in most instances, you will need to sponsor people. So if we move on to the next slide. So sponsorship is essentially a contract between an employer and the Home Office to say, Home Office, if you allow us to bring skilled workers to the UK, the Home Office will make it easier, genuinely easier than we see in most other countries around the world. Essentially, to become a sponsor, you are I mean, the slide does a decent job of going through the process. And to give you the full rundown would take an awfully long time, but you're essentially submitting documents to the Home Office to demonstrate that you are an active and trading real company, not an immigration factory, I suppose, is how the Home Office might look at it. But if you're on this call, you're going to be a legitimate company, and they would recognise that. You will need to evidence it. There is a fee to be paid, and then essentially the Home Office will consider, and if you are granted a licence, you are then able to sponsor foreign workers, and in return you must be in a position to ensure that they will do the jobs that you said that they're going to do. They're paid enough money, and if their circumstances change or they leave your employment, you let the Home Office know. If you don't have a sponsor licence already, but you think that you're going to be recruiting people from overseas in 2021, I would say apply for one sooner rather than later. The process for it takes, all in all, 2 to 3 months, normally about a month for an employer to collect all the documents up. It can be a lot quicker, but it tends to be 2 weeks to 4 weeks. And then another month, maybe a little bit longer for the Home Office to decide the application. Once you have the license, you can begin to sponsor. And if we move to the next slide, essentially for sponsorship under the new system, if you're used to the points-based system that existed up until the end of last year, you're going to find a quicker, smoother system. There's no longer a need to advertise for 28 days in the job centre like there used to be. There's no longer a cap on numbers, for now at least. Instead, the individual needs to be employed or at least engaged by an approved sponsor, so you need that license. They need to be in a skilled job, which is A-level level and above, and they need to be able to demonstrate that they can speak English by being from a majority speaking English country or by holding a recognised certificate. They need to be paid typically £25,600. It can be higher though if they're in a skilled job. There are different levels of salary for every job in the labour market, and it can be lower if they're younger, if they are in a PhD job, a shortage occupation, and so on. Make sure that you look carefully, and the Home Office is a reasonably helpful tool for you to work out whether or not your job is considered sufficiently skilled, and then to look at what you need to pay them. If we move on to the next slide, there is also a category for multinationals. I'll be quick here, but if you are a multinational, it may be possible for you to bring people over on what's called an intra-company transfer visa from one of your overseas entities. Typically, we don't advise that clients use this. They don't get to stay permanently, and the categories for skilled people, other people can still come to the UK, and here we're thinking about what we tend to call self-sponsored. If we move on to the next slide, you'll see there is also the UK ancestry visa, which is for people with a British-born grandparent, where the individual is from the Commonwealth. Spouses and partners of British citizens, Irish citizens, and people settled here can come over. You have the Youth Mobility backpacking visa, which if I was backpacking in the UK, Brighton would be the one at the top of my list, I'd say, to visit. That allows people to work for up to 2 years. Students can work, but only in defined circumstances. And then there is also indefinite leave to remain, which means that people have a right to work in any job that they wish to. And then finally, I'll just go on to an extra level to right to work. Essentially, your right to work obligations for Europeans haven't changed if we move on to the next slide, yet as a consequence of Brexit. You only need to see that a person is European and keep a compliant copy of that passport or document until the end of July. From then, any new employees, you will also need to see their right to work. But do take a look at the pack that we are circulating by the Chamber, because in there we have guidance for you to use, which will help people understand that even though you only need to see their passport, they will need permission to work in the UK as well. And with that, I'll skip over the next slide because I've used a little bit longer than I'd planned to, and go over to Andrew to talk about people who are travelling into Europe.
Okay, thank you very much, Ian. So I think we wanted to highlight some issues around Europe as well, because there is obviously a temptation to think that Brexit's a UK issue alone. So we wanted to go through some things. If we move on to the first slide in this section. So just to go through the types of people who are affected by Brexit. So broadly speaking, you've got the people who were in Europe before the end of the transition period, so before the end of 2020. Now, those individuals will consider themselves quite lucky, perhaps, because they already have status and they were protected under the withdrawal agreement between the Brexit withdrawal agreement, as long as they were legally residing in their European country before the end of 2020. What they have to do in order to protect those rights that they had is, in most jurisdictions, they'll need to obtain what's referred to as an Article 50 residence permit. And in many jurisdictions, the countries were allowed to opt for what they call a constitutive system, where they actually require UK nationals to obtain this, and they can lose their rights if they don't do so by an imposed deadline. And in other jurisdictions, which are known as declarative, which is the majority of the countries in the EU, they need to obtain that, but it's more of an administrative issue. It still is important that they do it, though, because it will lead to fewer problems when travelling. So those were people who were in the EU already. Those who are travelling to the EU from the 1st of January, obviously, are in a bit more of a difficult position, because the member states have their own rules about entry and work requirements, depending on the jurisdiction involved. So each of the member states will have its own domestic system, and that can complicate things because there are different requirements across each of those jurisdictions. And that's why employers really need to consider things like timeframes. They need to consider the costs involved in moving somebody from the UK into the EU, and also certain compliance elements that we'll touch on later. Just to touch on the fact that right to work is evidenced by different documents depending on the jurisdiction involved. For those who were already residing in the EU, it'll be primarily the Article 50 permit that we discussed earlier, but for those who are arriving in the EU from now, it will be different requirements, such as work permit, residence permit, and so on, depending on the country. Really importantly, though, there's also people who are travelling to European destinations for business. Now, I think it's a big mindset change to think that, that as a UK national, for example, I need to think about what I'm going to do if I'm travelling to France. I can't just, hot-foot it to France and not worry about how long I'm going to spend there or what I'm going to do while I'm there. I actually now need to consider, in the same way as an American national or Canadian or Japanese national travelling into Europe needs to consider, I need to think about how long I'm going to spend in the Schengen zone, which encompasses most of Europe, and also how long I'm going to spend there and what I'm going to do while I'm there. So whether my activities in France or Germany or wherever are going to conform with business visit requirements. And what we could consider is whether there are work permit exemptions available for UK nationals travelling to particular destination jurisdictions, and also whether there are exemptions available under the recently established trade and cooperation agreement that was entered into sort of at the 11th hour at the end of 2020. I will just note that, similar to what Ian said about Ireland, or what Katie said about Ireland, the relationship between the UK and Ireland obviously predated Brexit, and therefore predated the European Union even. So UK nationals are still able to go and live and work in Ireland as well. So if we move on to the next slide, I was referring before to the Schengen zone. So what do I mean by this? So, and I said that it encompasses most of Europe, and you can see in the blue shaded section there that that's indeed the case. Now, why is it called the Schengen zone? It's just named after the town in Luxembourg, I think it is, where it was first ratified, just to clarify that point. In the true spirit of bureaucracy and complicating things more than necessary, of course, there are countries which are in the EU but not in Schengen, countries that are not in the EU but in Schengen, and so on. So you can see those shaded differently across that map. But broadly speaking, it's important to consider the fact that one can only travel into that whole Schengen zone if you're a UK national or any other non-EU national who is not subject to visa requirements for a maximum of 90 days in any 180-day period. And that's whether you're traveling for business or for for tourism. So those things are combined. If we move on to the next slide. So I've spoken so far, quite a lot about sort of business travel and what we need to do. In terms of actually bringing somebody to an EU country to work, we said before that there are various different things to consider. I think these are the really critical red flags that you need to bear in mind if you're recruiting into Europe from the UK. It's going to be a lot slower because processing times in different jurisdictions can vary. It can be many months in some jurisdictions, I'm afraid. There will be obviously increased costs. There'll be government fees. There'll even be fees for the likes of Fragomen, who will tend to charge for services, and of course in some instances you'll also have to consider social security as well as tax implications as well. Of course, there are different things that you need to bear in mind in terms of compliance. So because there are so many countries across the EU, each of which having its own different domestic rules, it's quite complicated. We can consider sort of intra-EU mobility options if somebody needs to work across a different number of countries. So that's something to consider, but it's not always quite so straightforward. So it will be a question of determining, depending on the circumstances, what rules apply and what the work permit requirements would be. We've spoken about the time limits in relation to business travel, but I will just point out as well that in terms of eligibility criteria for work permits in different jurisdictions, there will be requirements such as educational background and or level of experience, such as degree qualifications, as well as minimum salary or market conforming salary requirements. And the further complication can often be that in the case of degree certificates and so on, a lot of those need to be legalized and so on. So that can really increase the time frame. So if we move on to the next slide. Thanks, Laura. So I've included here just a sort of a heat map of what we see across Europe in terms of restrictive practices in order to obtain a work permit. Now, I should point out that this map, and it's sort of it gets more difficult as you get more into the sort of orange-red zone. But I think it's important to point out that it is a blended point of view, because if we look here, for example, I can see that the UK and Spain are sort of put on the same level. I would say that that's probably because for example, Spain might be much more difficult in terms of documentary requirements, legalization requirements, and worse for timeframes, but it's probably considerably cheaper than the UK. So all in all, it sort of blends as those aspects are considered. Nevertheless, it gives you a sort of bird's eye view, and the factors that we've included are quite varied. So all of those bear in to the overall country colour coding. So if we move on to the next slide, thanks, Laura. So I mentioned before that there are complexities in terms of compliance and documentary requirements. These are some of them that will need to be considered, both for business travel and also for work permit requirements. So obviously there would tend to need to be a work contract in place, an employment contract, or an assignment letter in the case of a short-term assignment. Individuals would very often have to produce evidence of their degree. There would be salary requirements, as we mentioned, and those vary depending on the jurisdiction and the type of permit involved. In the case of intra-corporate assignments, you would also need to demonstrate that the sending entity of the UK and the receiving entity in the EU jurisdiction are the members of the same group. And there are various other things that also impact on business travel. So having a valid travel document should be second nature, of course. Health insurance is quite an important thing to consider now, because when I travel to the EU, for example, they may well ask me at the border, have you got comprehensive medical insurance for the duration of your stay? And I would need to, if asked, evidence that I had that. And of course, the last point that, to be honest, this isn't that much different from from how things stood previously, because of course, if somebody is deemed a threat to public policy or security, then they're most unlikely to be awarded a visa. If we move on to the next slide, I'm not necessarily going to propose to go through this case study in detail, but I wanted to give you a sort of a flavour of how things might look for somebody who, for example, is being employed in Germany from the UK. As you get sent these slides following the presentation, this will just give you a bit of a flavour for how things might look for a relatively straightforward application to Germany. And one thing that you can note from there is the processing times of 6 to 12 weeks. So it is important to bear those things in mind as you navigate the Brexit minefield, and as you might want to recruit people from the UK into European destinations. So I think that's it from me. I will hand back to Sarah.
That's brilliant. Thank you very much. Just actually a quick question for Ian before we open up with questions. Ian, can you say a bit about how much it would cost an employer to sponsor an employee? How much would they have to pay?
Yes, of course. Can you? Yeah, you can hear me. But by the way, one of my daughters has invented a song, and the other one is shouting, "Where is Daddy?" So if you hear that, that's why. Sorry. So the UK immigration, the government has made it deliberately expensive because they don't want high immigration. What that means is that if you were sponsoring, if for instance you were sponsoring me as a single man for 3 years to come and work in Brighton, you'd be looking as a small employer at spending about £3,900 in government fees to sponsor for 3 years. If I was coming over for 5 years and I were married with 3 children, then in government fees alone, I totted it up earlier, that would be about £25,000. Really importantly, the fees that you need to pay are, it will be about £367 per year as a skills charge and £199 as a one-off cost for a certificate of sponsorship. The other fees, the government expects the employee to pay the other fees, which are the visa fee and the health surcharge. You will want to take a look at that, look at the budget and decide, will you pay those fees for your employees, or would you expect them to? And broadly speaking, it's about 50-50 for our clients as to whether or not they pay. If you're a massive American bank, you probably pay. If you're a big Silicon Valley tech company, you probably pay. If you're a small firm, it's less likely, but it depends on your particular situation and how desperately you need that person, really.
Okay, great, thank you. So we've got some questions. What I'm going to do, because I haven't run one of these before with 4 experts. So what I'm going to do is I'll say the question, and then whichever one of you wants to answer it, perhaps you could unmute and jump in with the question. So the first question is about seasonal agricultural workers who typically come into the country, you know, for example, for a vineyard and work for a season. So what would the employer need to think about with them? Katie, I think you need to unmute.
Sorry, you'd think after a year I'd know that by now. So unfortunately, entering as a visitor is extremely restricted as to what you can do. And the government have a specific visa category for seasonal workers. It's called a Tier 5 category, which relates to temporary visas. So the sponsor or the company that want to hire that individual, they'll need to apply for a sponsor license, which is what Ian discussed when he referred to sponsoring non-UK migrants. And only once the company has a sponsor license can they then hire an individual under the Tier 5 seasonal worker route. And they can stay for a maximum period of up to 6 months. And what they can do is very restricted. In the document called a certificate of sponsorship, which is sent to the Home Office, the employer will need to set out exactly the job duties of that individual and what they're going to be doing, and they have to stick to that. And importantly, they can only stay for up to 6 months. But unfortunately, even if they're coming for 2 to 3 weeks, because it's actually productive work that they'll be undertaking and not entering as a visitor, they will need to apply for this visa in order to enter and start working. So the company gets the sponsor license. The company then assign the individual this online virtual document called a certificate of sponsorship. And only at that point can the applicant then apply for a visa application to enter the UK. And this application is made outside of the UK, and they can only enter once the application's been approved.
Okay, thank you very much. I think this one might apply to quite a lot of people, where what happens when you have UK nationals living in Europe, but working with the UK organisations. So this could be trainers or translators, for example. So what would the UK employer need to do? What do they need to think about?
Well, that's quite a complex question. We would have to look a little bit more in depth into the arrangements, whether we are looking at the employer relationship or more of freelancer relationship, and also the status of the individual who is currently in Europe. Right now, as Andrew explained, that there is a possibility for those who are residing before the end of the last year in Europe, in the local employment capacity, so employment with a European entity, or on the basis of self-sufficient funds, are able to apply for Article 50 residence permit based on the withdrawal agreement. If we are talking about the secondment, where the employment remains with the entity in the UK, and this person is temporarily posted to a European country to do work in that European country, we have to look on a country-by-country basis. In some of the countries, it is possible to also obtain Article 50 residence permit. In the others, it may be needed to obtain a work permit. Czech Republic is a perfect example, where for posted workers, they have introduced the requirement to obtain work authorization. So there's not a single answer to entire European region. It has to be analyzed on a country-by-country basis.
Yeah, okay, thank you. Can you say anything about overseas students wanting to work during the time that they're studying in the UK?
Yeah, I can take that question. So overseas student will have to apply for a visa before they enter the UK. It's called a Tier 4 student visa, and they do have restrictions on their employment. So during term time, they can only work up to 20 hours. And then during the holidays, they can work full time, up to 40 hours. And this will entirely depend on the term time, which is set by that university. So if you're looking to employ a student, it's really important that you get their calendars and see when they're allowed to work part-time or full-time. And they can also work once they've completed their studies, as long as their visa is valid, they can also then work full-time. And then finally, after a student has graduated, from July of this year, the government are introducing a new route called the graduate visa route, which enables graduates who've graduated from the UK university. They can stay in the UK, they'll have to apply for it, but they can stay in the UK for a period of 2 years, and they can work in any role, and there's no minimum salary.
Okay, great. And are volunteers affected by the new immigration system?
So this is a really tricky point. It ultimately really depends. So the Home Office make a distinction between volunteering and undertaking voluntary work. So voluntary work would suggest that there is a contract in place. Even if they are unpaid, they would still be regarded as undertaking productive work. So if you wanted to hire a volunteer, you'd have to make sure it falls within the remit of volunteering, i.e. there's no contract in place, they haven't fulfilled a particular role or undertaken a particular role with the company, they're under no obligation to work a certain amount of hours, they can come and go as they please. So I'll just use the example, my dad is a voluntary gardener at the local animal shelter. He can come and go as he pleases. There's no requirement for him to work a set number of hours. So that would be considered being a volunteer, but not voluntary working.
Yeah, Okay, thank you. So thank you, Andrew. I know you're answering some of the questions in the chat, which is brilliant. Here's another one. We currently have a sponsor license, and the candidate unfortunately had to go home, so we will not be using it. Do we have to inform the Home Office?
I can answer this one. So you don't have to inform the Home Office if you have a sponsor license, it will just expire. But if you have actually sponsored that individual and you've issued them with a certificate of sponsorship, then you are required to notify the Home Office that you no longer sponsor that individual. And you can do that by logging into the sponsor management system, which is a website. You should have received your login and password when your sponsor license was approved. And you'll need to let them know that that individual is no longer working for them. And you do usually have to make that notification within 10 working days. If you haven't done that, don't worry, just make sure you do it as soon as possible. But if you didn't sponsor them and you still have a sponsor license, then you're under no obligation to let the Home Office know.
Right. Okay.
No, and to be honest, it takes so much time to get a sponsor license. If you never intend to use it again, then perhaps it makes sense to rescind it so that you're not on the hook for compliance, although who needs to comply. But it's such a burden to get the license in the first place. I would think carefully before giving it up, to be honest. But do seek advice if you feel like you need to.
If the EU person already has an NIN but doesn't live currently in the UK and wants to move to the UK in half a year, is he eligible to apply for pre-settlement status?
It's a really good question. So in order to apply for pre-settled status, they would have to have established their residence in the UK before the end of the transition period. So there's 2 points there. Firstly, if they want to apply for pre-settled status, they have to provide a document which shows they were resident in the UK 6 months before the end of the transition period, i.e. from about July 2020 until now. It's always important to ask these individuals who want to apply under the scheme if they've ever in their entire lives spent a continuous period of 5 years in the UK. Because if they have, they are potentially eligible to apply for settled status retrospectively. So in order to make that application, they would have to show that they've been resident in the UK for that 5-year period. So they could provide their national insurance number, employment contracts, for example. And then from the point they left the UK, they then also need to provide evidence that they regularly returned, i.e. to maintain this retrospective settled status. If they weren't in the UK for a continuous period of 5 years and they haven't been to the UK in the last year, unfortunately, even though they have a national insurance number, because they haven't actually established their UK resident, they haven't been physically present in the UK, they wouldn't be eligible to apply. But that might be one if there's a specific circumstance. I'd be happy to help later.
Okay, great, thank you. Right, we've got good 4 questions. Hopefully we can rattle through these. This might be a yes or no answer. I'm an EU national with settled status in the UK. Can I become a sponsor?
Your company? Oh, is that your company or as an individual?
I think it probably. Well, I'm not. I guess we should.
Both.
Yeah, maybe both. Yeah.
So if you are married or you have any children or any dependent relatives like a mother or father, then yes, you can be an EA sponsor. They can apply. If they're outside of the UK, they'll need to make an application called a family permit, which enables them to come into the UK. And then once they've entered the UK, they would apply for pre-settled or settled status, just as long as that relationship existed before the end of the transition period, i.e. just say you're married to someone, that marriage took place before the 31st of December. If you had a company and you wanted to hire non-UK nationals, then yes, subject to all other eligibility and suitability requirements being met, you can, as a permanent resident holder, you can potentially apply for a sponsor license. But that will really depend on the company. Just for example, if it's active in trading, there's quite a few requirements for a sponsor license that would need to be met.
Okay, thanks. Okay, could I ask what would happen with recruiting self-employed people in the UK who are EU nationals? Our teachers are self-employed. Would I need to make sure they provide the proof of their status, settled status, etc., during the recruitment process? Then is there anything else we would need to get them to provide?
So do you want me to give Katie a break for this one? Where you are recruiting a European national for the first 6 months of this year, so up until the end of June, you simply need to know that they are European. So that will mean typically taking a look at their passport and keeping a compliant certified copy of that passport in line with regular right to work guidance. In the background though, the individual will need to have the right to work and the right to live in the UK. Because for instance, if they arrived from France on Wednesday, start working with you the following Monday, but were entered as a visitor, they would have no permission in the UK, and they could accidentally assume that they are in the UK legally because you've conducted a right to work check. You will be covered. I mean, you would have no substantial corporate compliance risk there. But when they find out in 3 months, 6 months, 6 years, 20 years that they don't have permission, then this is the Windrush issue, where people are essentially refused the right to work, the right to rent, the right to access some healthcare, get a driving license, and so on. So if you take a look at the guide that we will send around, we've included in there that the Home Office have put together a really good guide for employers to say, you need to have permission to work, this is what to look for. But it's about 7 pages, which I have never read a 7-page document given to me by my employer, probably not even my partnership deed actually. So instead we've put together, it's about a side of A4 text, just that you can print out and pass to the individual to say, this is what you need to understand. Please let me know if you don't have permission to work, and we'll see if we can help you.
And does that apply to somebody who's self-employed?
Yeah, and then the options, if they were here before the end of last year, they will have pre-settled status. They should have pre-settled or settled status. Doesn't matter if they're self-employed. If they arrive from the beginning of this year, they would need permission to work in the UK. And as a self-employed person, it's really tough. You can sponsor them with a skilled worker visa, but it's more complicated than usual. Definitely get advice on that. It's hard to be able to track and monitor in the Orwellian way that's expected a self-employed person as compared to an employed person. It may be that they can qualify for youth mobility, or they've got a British spouse, or they can otherwise be self-sponsored. Possible, but really hard for self-employed people, and I can see why it could be particularly hard for self-employed teachers. There will be a self-employed visa category from next year for highly skilled migrants. This is Boris Johnson's points-based system, but we don't know how that will work yet. So it's complicated. If your business model relies on recruiting self-employed people, then I would be seeking advice on the specifics, because it could go wrong for you and them, frankly.
Yeah. Okay. I think that's clear. Good advice. So, is there an indication of what happens after 5 years of settled status? Will the EU nationals with SS then be told to take citizenship in order to stay?
No, they won't. So they can if they want, but they don't have to. Settled status gives you. So to start at the beginning, someone said, how do you apply for pre-settled status, and what do you get? You apply on an app, the EU ID checker app. It takes about 15 minutes. It's all very intuitive, but our guide that we will send around will be really helpful for people. They'll get a decision back a couple of weeks later, and it's rare that a person is refused where they are European and were in the UK before the end of last year. The email will confirm that, and then their status will be digital rather than a sticker or a stamp in their passport. That if they've been here for less than 5 years, they will be granted pre-settled status, and once they've been here for 5 years, they need to make a second application for settled status. If they'd already been here for 5 years, the first time around, they'll get that straight away. Once you've got settled status, you aren't British, but it does lead you on to, it does allow you further down the line to apply to become British, but you don't need to. Settled status is indefinite leave to remain. You would only lose it if you are a serious criminal, and serious criminality would tend to be a year in prison, or at least sentenced to a year's custodial service. or if you leave the UK and don't return for 5 years, it's your right to stay permanently.
There's a question on settled employees applying for EU settlement scheme, and what are the risks? I'm assuming that means, you know, is there a risk of being turned down? But I know locally there's a big campaign locally to encourage people to apply for settled status. So are there risks? Are people turned down?
Can answer this. So the UK government want to grant these applications, and they've advised that someone will only be refused if they have any serious criminal convictions or they just don't meet the requirements. So if they didn't enter the UK before the end of the transition period. The biggest risk is that people don't apply. It's so important to get the application in as soon as possible. The deadline is the 30th of June, but we're just strongly advising people to apply now just to ensure that they have their status before that date. But otherwise, as Ian said, it is a relatively simple application. If anyone here knows of anyone that's having issues, then obviously we would be more than happy to help, but the guide that we'll send round will provide a step-by-step explanation of how to apply.
Great. And just
the one risk with people is that, I was just going to say, make sure people, if they've been here for 5 years, have been granted settled status, not pre-settled status, because that's where mistakes have come in, people being granted the wrong thing. I think because they've requested the wrong permission. Generally, it's not necessarily the Home Office mucking up, but keep an eye on that. Sorry, Sarah.
Last couple quick things. So, if we're visiting Europe for meetings, but we need to check if how do we check whether a work permit is needed? I think you were saying it's okay to go for meetings, but sometimes you need a work permit if it's a bit more than just meetings.
Indeed, and I'll take that question perhaps. There's no good source to get all the answers in terms whether you need work authorization or you don't need work authorizations. Perhaps like what Andrew mentioned, generally going to Europe to meet with another business, to negotiate and undertake simple business activities generally is permissible. But when you need to do something that will be indicating productive work, or it is part of the nature of the job, normally this is considered as work. Therefore, it will be important to identify whether in particular country such activities can be exempt from work permit requirement dependent on activity type, occupation, potentially length of the activities. Those are very limited, and there is not unified approach across entire Europe. And every country will have completely different set of permissible activities. So you do need to consult with someone who has perhaps the appropriate knowledge. Of course, we will be happy to help. You can check with the consulate, although consulates not always are qualified to answer whether work authorization is needed or not needed, because this is competency of labor authorities in general. Sometimes the authorities have joint responsibilities, but the consulate will take usually very high level, unless there's a very clear visa type that they can advise on. For example, if you are in, I don't know, in media industry, in some of the countries you will have media visa or sport visa that is specifically indicated on the consular website. But other than that, those activities need to be clarified. And there's trade and cooperation agreement. Unfortunately, it does have a list of activities that we would like to rely on, but unfortunately not every country introduced those in their national legislation. So provisionally they're applicable, and in some countries like in Belgium, in the Netherlands, those activities are respected, but other countries are still considering like how to apply it, because they have to adjust their national law in order to be able to have those introduced.
Great, thank you. Sounds like the subject for a follow-up session to me. So I think we've come to the end of our time with you. So I wanted to say a really big thank you to all four of you from Fragomen. It's been a really useful session. Thank you again to Brighton Hove City Council for helping us put on these sessions. We have got another Your Questions Answered session scheduled for next month. So that's the end of the session. Thank you all for coming, and we look forward to seeing you all again soon.